Yes, what is this matter about?
Your Lordship, we are challenging the selection process, Your Lordship.
Selection process.
Yes, Lordship.
Any interim order here?
No, Lordship.
Selection is complete. It's taken place.
No, my lord. Here, my lord. Here,
The selection
state
process is not over.
basically a formal party. MPSC will be in a better position to address that, my lord.
No, whether the selection was completed, it was.
I don't think so, my lord.
Lordship, if I may, in this case, the petitioner had participated in the selection process, and there were claims of nepotism against her. That's why this, when the recruitment happened, Lordship, at that point of time, it wasn't compulsory for written examinations. It was direct interviews that would take place for recruitments in the various posts that we would advertise the MPSC. But right after this case
This
was
post
instituted,
was for what post? Which department?
Ayurvedic, Lordship.
Ayurvedic doctor. And then that selection process was challenged
Yes, Lordship.
after participating there.
After participation, Lordship.
Why he was disqualified? The petitioner was disqualified over.
Lordship, we did away with the entire selection process. So she's challenged the revocation.
What made petitioner challenge this? There must be cause of action, isn't it?
Lordship.
Did she fail in the exam or?
No, Lordship. It's only on claims of nepotism, Lordship, because in the interview panel, there were claims that
She tried to influence.
there was a
Complaint that she has some relative in the panel who were conducting the interview. So therefore, my lord, the entire recruitment process was called and the petitioner was not appointed. The petitioner is not appointed, so it was recalled.
Was petitioner selected? The question of appointment comes later.
The petitioner was the most sought candidate, my lord.
So there was a preparation of merit list. It means.
no, Lordship.
No, my lord.
So then where this cause of action came? Just because there is whether this interview was cancelled, the selection
Lordship, it was recalled, and written examinations came
it was
into being.
recalled. So then what is the purpose of this petition then? If
Lordship,
the
even
selection process was recalled, it's not completed, then what this court will interfere with? What is under challenge here?
Just the selection process, Your Lordship. And
Process is say, supposing if that is that this thing was recalled, this selection process,
Your Lordship.
then what remains to be challenged here?
Mr. Philoman will be in a better position, Your Lordship, since I'm not aware with the.
Okay, this also just after 2 weeks at the request of the petitioner.
obliged, Lordship.
Pleasure, Your Lordship.
Yes.
My lord, item number 9, my lord. Similar matter is pending before the
That POXO matter.
my lord.
Okay, this also just list after 4 weeks
For
on the joint request of the parties.
Deeply obliged.
Apologies.
Please, Your Lordship. Your Lordship, I beg to make a mention of item number 6 on behalf of Mr. S. Sen.
On behalf of Mr.
S. Sen.
is appearing for the state.
Lordship. Lordship, can you have the matter after 2 weeks, my lord?
What is the matter about here? Yes, madam, what is that? What is this? This is 2019 matter, isn't it?
Lordship,
A criminal petition pending from 2019. Why? What is the challenge here in this petition?
Lordship, I'm not the briefing counsel in this matter, Lordship.
Whoever it is, at least you should know the fact if you are appearing
Lordship,
here. The question is that there is a criminal petition pending for 2019.
Lordship,
Now, if it is an application for quashing, what is the purpose of keeping it pending for 5 years?
Lordship will have it disposed of in the next date.
When?
After 2 weeks, my lord.
What is the challenge here?
My apologies, my lord, because I didn't get a brief with me. My lord.
So then, at least if you stand up, at least you should know something. This is something very bad. The council appearing for the parties, nobody knows what is the fact.
My deeply apologies, my lord.
At least bother to read the brief at least.
Lordship.
With the request of the state to respond at least after 2 weeks.
Deeply obliged.
Obliged, Lordship.
Daily cost list, item number 1.
May it please
Yes.
your lordship. Lordship, as per the last order, we are to file the objections, my lord. My lord, I seek your indulgence. Kindly me some time to file the objections.
Mr. Since you're paying for the state respondent, please for grant of further. How long? How long? 2 weeks.
2 weeks, my lord.
2 weeks time for filing an objection to the mayor. The no counsel of the petitioner has no objection. Prayer allowed. List after 2 weeks.
Deeply obliged.
Yes, my lord.
Item number 2. Item number 3.
May it please your lordship, I am appealing
Yes.
for the petitioner, my lord, in this matter.
Yes.
Matter relates to, my lord, to use of, my lord,
Yes.
playing of, my lord, vehicle, my lord, by my lord,
Objection?
state was supposed to file affidavit, my lord.
My lord, my friend has paid for objection, not the state, my lord.
So that's one number 2.
Affidavit on Friday, my lord.
We have received
We filed a
objection.
affidavit in opposition on Friday, my lord.
You'll file it on Friday.
My lord, they have already filed, my lord. Their objections have been
filed.
filed.
I have not received a copy, your lordship,
You have not received.
my lord.
Do you have a local counsel here?
Yes, my lord, Purnima Rai, she is appearing. I contacted, my lord.
You supply a copy to the other side. It has been submitted by the counsel of the respondent number 2. That is no objection on behalf of the said respondent has already been filed. However, Mr. Goel, learned counsel appealing for the petitioner, submits that no copy has been received. No copy has been furnished to the appellant. Stop. The respondent number 2 shall furnish a copy of the objection to the appellant when?
Today,
During the course of the day. Stop. Then when shall when this matter should come up?
my lord, to the convenience of lordship and my friend who is appealing, we don't have
If
any.
not, 24th of July, your lordship,
We're
24th
not
of July,
giving a fixed date, see.
my lord.
My lord, one
Because
week.
I want to
One
come
week.
and attend before your lordship
No,
physically.
we can
my lord.
understand, but then we have several outstation lawyers. So once we
My-
accommodate one person, we have to
My
accommodate
lord, it is your lordship.
tentative things, and then since you have a local counsel, you verify and then
My lord.
things. So we'll
As
have
your
it,
lordship.
have you after 2 weeks.
My lord.
Will it come up for hearing directly or
I
anything?
think, my lord, in that day, my lord, your lordship may dispose it off, my lord.
It can come
Because
for
they have
hearing, my
filed-
lord.
Okay, then we have put the paragraph as prayed for by the parties. This matter for hearing after 2 weeks. Yes.
My deeply obliged.
Item number 4.
Yes.
Lordship, we have taken step to service notice. Lordship, since the respondent is not here, you allow us to file a service report.
Okay. The office note dated 12/7/2024 indicates that service report, that the report of service upon the respondent number 2 has not yet been received. Stop. The petitioner to verify the status of service upon the respondent number 2 and file an affidavit to that effect within 2 weeks. List accordingly.
Deeply blessed.
Yes.
Hearing, item number 10.
Yes.
My lord, senior counsel, additional advocate general is leading this matter on behalf of the state. She is on legs before court
What is
number
the
1, my lord.
status of this case? What is the
My friend
investigation?
Paske
What
will
is
be
the
in a
status
better
of
position.
investigation?
Mr. Paske will be in a better
You
position.
are the
my
state
lord, to
counsel. He is a private respondent.
No,
What
my
is the
lord.
status of investigation? The court is asking about the status of investigation.
My lord, the most latest information I do not have, my lord. But apparently, my
But then
lord,
on the last week, that is what we wanted.
my lord, my apologies. I do not have the latest instruction, my lord. But it can be, we can produce, my lord. Because, my lord, what happened here, if I said, in the past, as we have apprised this court, there are a number of counter allegations, and also we have to segregate which portion, which particular case have been charged sheet and which is at the stage, my lord.
How many cases are there?
Their counter, my lord, I have to make a proper list, my lord, because as said,
You
they
take
are
a
not.
definite take instruction with regard to that. You see, the problem here is that
Which FIR is this?
this, whatever has been submitted on the other day, it appeared like a civil
3
dispute.
FIRs.
Now, of course, one thing remains is that their assertion of the petitioner, that the land was disposed of in their favor, okay, in 1969. Now, whether the entry of mutation made thereafter is genuine or not, if that becomes a question mark, then definitely we will not interfere in such a case. Now, because that is what Mr. General, see, it appeared like that, we understand, but then that is not the admitted position that you bought the land in 1969.
Your Lordship.
Now, if that is not the admitted position, then the entry of your name in the land record, that is what the subject matter which requires to be investigated upon. And in such a case, we cannot say that there is no case.
Lordship, think this
At
first
least
of all.
then such a case we can say that there is a case for investigation.
First of all, Your Lordship, such a allegation is not in the FIR. This type of allegation is not in the FIR. Second thing, Your Lordship, the records are here. It is annex.
Your Lordship has sought for a family tree also.
Yes, definitely we'll come to it. But then you see, like the thing is that the question of going into merits to determine who will be rightful owner, who is not, and whether at all that land required to be partitioned or not, let those be decided by the civil court, not by the writ court. Now, right now, what we are concerned about that whether there is any allegation in the FIR which needs criminal investigation. That is what. So we will not go into that thing. I don't think that
just take you
we
to
might.
Annexure 5 of the petition.
On the last hearing, probably we went something, we went deeper into the issue, but then ultimately it appears that is the only thing. If their entry is alleged to be a fraudulent entry in the record, then definitely that is what is to be investigated.
Your Lordship,
apart from your entry, name of entry in these things, what is your title deed?
Lordship will come to page 29.
Okay, that is, of course, that is a question may not be very much relevant, but then.
And this is also, Your Lordship, settled law that criminal.
29.
Page 29.
That is, what is this?
This is mutation record.
That is all right. That is entry in the revenue record.
There is
entry in the revenue record is not a proof of ownership. See, title is something different. The entry is made on the basis of the title. Now, this entry, whether it is genuine or not, that is what the question is. Now, if that be the question, then it requires an investigation. Just because your name is entered in the record or in the land record doesn't mean that you become owner. This is what the law is. If you want to say that you have a ownership, to make it totally a civil case, then the basis on which this entry has been made, that becomes relevant. Whether it is by a sale deed or by a gift deed or by any other.
Your Lordship,
My lord, if I may interrupt, my senior colleague has information with regard to the case where we filed, my lord. He'll be in a better position to answer the lordship's query, my lord. Mr. Bhattacharjee has the record.
That is about the status of the case.
My lord.
Yes, what is the status? Please come this way. Come this way. Come this way. Come. What is the stage of investigation?
The investigation could not be completed, my lord, because they are also not receiving
cooperation, my lord.
No, but
Even
then
as far as
official
the
record. This is the official record.
My lord,
See,
as far as
see what the thing is that what this court is interested to know is that about the entry of the name of the petitioner.
yes, my lord, that we all have in original, my lord. And the this is the, my lord, periodic lease patta, which is here, my lord. We have the original Jamabandi.
So this,
and we also have the statement of the petitioner's father, my lord. In fact, father-in-law, Anujain Bhora, where he is clearly stated, my lord, that they don't any land in Thura, my lord.
So in such a case,
father-in-law, mother.
It means their entry of their name into the record. That is what requires to be investigated.
My lord.
Mr. Jindal, in such a case, you will have a difficult situation.
Lordship, first of all, there has to be some allegations in the petition, and
what
the
FIR at what page?
page 16.
Your Lordship, page 4, para 4,
Para 4,
page
see.
17, second para.
See, that is what that is where allegation of illegal mutation has happened. Now that is what the thing is.
Lordship, when the thing they say it is against the Land Transfer Act.
Whatever it is, but then if it is entry is illegal, then maybe criminality may add us to it. You see, we cannot see just because simply an allegation prima facie appears to be civil in nature doesn't mean that there is no criminal act involved here. That is what the decision of the apex court later is the decision of apex court.
Yes, Lordship.
Okay, now if you can say it is exclusively civil matter and there cannot be any criminal imputation, then definitely you have a case. But then in view of this,
Your Lordship,
supposing
the criminal process cannot be initiated thus to have a fishing inquiry.
no, where we are not having, see, fishing
No,
inquiry
here-
means what? If any no proceeding has been initiated till now, it is just the stage of investigation. There is
Lordship,
no initiation of proceeding against you. So proceedings comes after the matter is investigated. And after the investigation, if again investigation is resorted to find out, then becomes a different thing. Here we are not on this.
Your Lordship, my submission still remains that
It's okay.
Your Lordship, on the face of it, there is nothing, and there is also nothing to show that entries made in the revenue records
Yes.
are false. Nothing to show.
Now, you see,
After all, these entries are not made by me.
except for forgery, you see what is there and what is not there, that we cannot go into the thing. You see, in the FIR,
There is no forgery, there is no cheating,
no, but then see,
and there is nothing to show that a fraudulent document or forged document.
the question comes on what basis this entry has been made in the record of mutation.
Well, there is an application.
Tell us what is the basis of entry.
There has to be an application, my lord.
Wait,
There must be, Your Lordship.
please take your seat. Please take your seat. Let us see. Do not get agitated. We are having interaction, nothing. See, the court has not decided anything till now. See. Now, what is the basis on which your name was entered into record, mutation record? Just say.
Your Lordship, page number 28. This is a part of the land, Your Lordship. Again, I am repeating,
See,
Your
this
Lordship.
is again a record of land. This is a part of land record. The question comes, since it is your case that the original owner was somebody, then he disposed the part to you.
Yes.
And then instead of, you see, like thereafter, after disposal, instead of partitioning the record of mutation or the land record, it remained, the whole part remained. But that is what the confusion. Now, if you say that it was sold to you, it was transferred to you, on what basis it was transferred to you?
Lordship, it was transferred to my grandfather. At that time, even I was not born.
Now he's 69, you say?
67.
67. Now
67.
67, by what document it was transferred to your grandfather?
This, your lordship, I won't be in a position to tell because here it is done by my grandfather in the year 1967.
So it's okay.
And it is at the relevant time even I was not born. And lordship will further see a Diochen Jain first.
Mr. Jindal, I am residing in a place, it's an ancestral place. And it was originally bought by grandmother. I have the document.
Lordship here.
So,
here
you cannot just take a plea that it was bought by my grandfather and I do not have, I cannot say. It cannot be. Their land document will remain there. This original title document will remain there. So anyway, we will take note of your submission. There is no problem.
And on what basis the mutation is made, that document must be with the district council, your lordship. Because otherwise, how they make the here, your lordship, it is mentioned.
So let it be found out by the investigation. Now, if you do not know on what basis your forefathers came into the then becomes difficult. Then it becomes a case to be inquired. Now, if you have ready-made something, then definitely we may take a different view. But then, if you are not been in a position to divulge on what basis your name has been entered into the records. And their case is that there is an illegal entry. Now, illegal entry, whether that has been done in 1967 or recently somebody has entered by putting that date, that is a matter of investigation. So, we cannot say that there is nothing in the FIR which requires criminal investigation.
And your lordship, this complainant, who he is after all, your lordship, I have.
Can you give us the latest status? What is the latest status of the investigation?
My lord, the last entry, my lord, because he said that he is not finding cooperation, and my lord,
no, not
after
finding cooperation. What is this? The official documents.
My lord,
you may not get cooperation from the petitioner, but then what about
my
this?
lord,
This has to be prepared.
He is approached the district council also, my lord. The last entry in this case is, my lord, dated.
No, who is the petitioner has approved? Who is petitioner?
My lord, the last entry is 16/3.
No. Petitioner is not official of the district council.
Petitioner is not, my lord.
Then
petitioner is
not. No. Then who is not cooperating?
My lord, even the district council, my lord, that's why they should be made a party, my lord.
You are the investigating authority. You know which way to investigate the matter, and you have all the powers in investigation.
That is there, my lord. So, my lord, the last entry is dated, my lord. This is 16/3/2024. However, my lord, will kindly.
That is 16/3/20. What about that entry where Mr. Jindal's name is there?
My lord,
1967. Now, when it came up, at least these documents will show.
My lord,
have we able to seize those documents?
Lordship,
my lord, some documents we have seized, but not all documents.
What are the documents you do not know?
My lord, I have it here, my lord. We have the case diary is here, my lord. We have the Jamabandi is there, and the periodic lease patta is there.
What about we are concerned about this land only?
My lord, the statement, my lord, may kindly.
Humble submission will be to remove this doubt. Let the district council produce this.
District council is, first of all, is not a party. Secondly, this court will not go into roving inquiry in a 482. See, sir, you know very well.
I know, your lordship, but on the petition, your lordship, that there should be something. Now, how my grandfather became.
Let's you speak. You will have Mr. Bhattacharya, you will have your opportunity.
How my grandfather he has purchased the land. My grandfather, half of the land was purchased by him, and thereafter he has the land was transferred to my father's name in 1969. Thereafter in 2007 it came on my name.
Now we can understand, sir, your submission. See, the problem here is that whether those entries in the land record are genuine or not. You see, this is, we can understand your session, we can understand your story. See, the thing is that For the time being, we cannot take your story as a gospel truth for deciding this matter. Because if we say take your factual disclosure as truth, then we have to take their factual disclosure also as a truth.
Your Lordship,
So we are not equipped to determine all those things, as you know it very well. Now the other day on the hearing, you were relying on this Bhajanlal's decision. Now Bhajanlal's decision says that if FIR makes out a cognizable offence, that is good enough. And here there is an allegation of illegal mutation. Now illegal mutation, if it is illegal, then definitely there's some criminal act is involved. If it is illegal. Now whether it is illegal or not, that is the subject matter of the investigation. If it is not illegal, you are safe. This investigation will not spoil you.
Your Lordship, I have made 2-3 applications to the District Council to provide me the copies of the documents of.
You do one thing, then in such a case, you apply for those copies from the documents to the District Council. If they do not do it, you can file a litigation by which you can compel them to furnish you. Until that time, we will keep this matter pending. Otherwise, at this time, honestly, sir, this court is not at all inclined to interfere.
As your Lordship desire.
No, this is all right. Now, if you want a decision also, we can dispose it of those. It's up to you. If you think that your submission should be recorded and court should decide, that also we can do. There is no problem with it. It's up to you. Whatever way you decide.
Application, your Lordship, is already made.
See, District Council is not a party here. Second of all, in this matter, it is not possible to issue any direction to the District Council.
Yes.
This is solely on you. How do you defend it?
Your Lordship can definitely ask the state agency, investigating agency, to procure the records on the basis of which these entries are made.
We cannot.
Otherwise, your Lordship.
In such a case, we will be supervising the investigation, which we will not do at this stage. See, 482 application is filed by you. Onus is entirely on you to make out a case.
So far, your Lordship, FIR is concerned. There is no allegation, and your Lordship will, as your Lordship has proposed, your Lordship will give me some time. In that case, I will approach.
That is all right. If you want that this court is ready to accommodate you, but then otherwise also, if you want that it should be decided at this stage, that also you can do. It's up to you. Choice is on you. Now, if you want that at least the grant of time may help you, you can take it. But if not, then we can pass orders. We'll definitely take into consideration all the citations and all those things which you have.
Your Lordship may observe in the order that petitioner made such a submission and he is permitted to approach to the District Council. At least
this will remain. That goes without saying. Now, Mr. On the other day you submitted probably some paper here. The last occasion, the list of. Did you submit a list of cases on the last occasion?
Yes, Lordship. I have submitted today also. You have given.
Now, do you desire this court should give you some time to obtain this thing, or you want to finish the matter today?
No, you should give me some time.
We'll just give him some time
just
find out. Did you return it yesterday? Understand? Then you give it back. Give it back. Don't give it. Then we'll just see you the day of final hearing. It is not returned. Just Mr. V.K. Jindal, senior counsel appearing for the petitioner. Please for grant of some time to procure to obtain some more instruction in the matter. The respondents have no objection. Least after 2 weeks. Think over. See, we have very limited scope. We have a very limited scope, and you know it very well. See, this court is nowhere. There's nobody to tell you about the position of.
Your Lordship, in this order, today's order, Your Lordship just may reflect that to procure documents from the district council, and the prayer is allowed.
You do one thing. You just say what we said. It says so and so. Sometime in order to enable the petitioner to obtain a requisite land document from the district council. Okay, give a full stop, then the respondents have no objection. District please. Obtain the relevant land documents. What is it? Obtain requisite land acquisition which may be relevant for the purpose of adjudication of this case. Okay, then you say the respondents have no objection. 2 weeks. We have passed order in your absence.
3 weeks.
Yes.
Just give me 3 weeks.
Okay, make it 3 weeks.
Item number 13.
Yes.
Yeah, please, Your Lordship.
Yes.
Lordship, this is a quashing of an FIR.
Okay.
The petitioner herein, Your Lordship, petitioner number 1 is the complainant. Number 2 and 3 is the victims of the alleged incident that had happened. 4 and 5 of the accused. There's one more accused. He could not be a part of it because he recently got a job, so he is on training, so he could not be a part of it.
He's not a petitioner.
He's an accused.
So you are not seeking quashing of the case in respect of that accused.
No, in respect of that case. But there is a
your quashing is only confined to the parties here.
Only the parties. The reason that he is not a part of it, I have enclosed one document to show
Doesn't
that
matter. Once he is not before this court,
Yes,
court is not going to
yes,
give any relief to anyone.
Yes. Now, first of all, Your Lordship, I would like to take to the FIR.
Yes.
FIR is at page 19. This FIR was filed in Khasi language. Its translated copy is in page 19, Your Lordship.
Yes.
This FIR was filed by the petitioner number 1. Now, he had reported an incident. I'd like to read here.
Yes.
With reference to subject cited above, I would like to complain against 4 non-tribal who had assaulted and causing injuries to my brothers while they were from Madanarating police station to Thembasuk at around 7:30 p.m. on the 26/8/2023. Those persons came with 2 motorbikes, stopped and started assaulting them with the helmet in the face of my brother without any reason. Those non-tribals who are involved in causing injuries to his brothers are Shri Manoj Guru, Shri Tenzing Sitan, Anshuman Thapa, and one other name not known. Therefore, we kindly request you to look and take necessary action in connection with the incident.
How many of these are party now here in this?
Yes, the person which he had referred to as the brothers are the petitioner number 2 and 3.
This Manoj Gurung and Manoj Gurung is a petitioner here.
No. Yes, he's not a petitioner.
Okay.
Tenzing is the petitioner.
Okay, and then
Anshuman is also a petitioner here. Okay. Now, the victim here are petitioner number 2 and 3. Names are not mentioned in the FIR, but who he referred to as brothers are the petitioner number 2 and 3. Welsing Thongni and David Thongni.
Okay, they are made accused.
They are witness. They are victims.
No, that is all right. We are asking about the accused.
Accused.
The FIR names 4 accused, 3 accused.
3
one
accused.
they could not name, isn't it?
Yes.
So out of 4, these 2 are here.
Out of 3, 2
Out
accused.
of 3.
Yes.
And the 4th one could not be named. Unknown. He has not been traced.
That again, no. He's not. He's not part of this.
All right.
So, victim petitioner number 2 and petitioner number 3, David
1,
Thomni.
2, 3, all are
1, 2, 3. Number 1 is the complainant. Number 2 is the victim. Number 3 is the victim. Now, number 1 is not involved in the incident. He's just a person who reported the incident. So 2 and 3 are the one who are involved. Now, Your Lordship, the investigation was carried out. The case was registered. The statement of the victim has been recorded. That is at page 49 of the petition, Your Lordship. Kindly come to page 49, Your Lordship.
Just a minute. Page?
Page 49, Your Lordship. Before I read this, Your Lordship, my argument, my contention would be just to satisfy Your Lordship that 324, section offence under 324 IPC is not made out. Now, Your Lordship,
Did you argue before the charge has been framed in this matter?
No.
So you argue before that thing.
We've argued it, but because not yet finished. But we have submitted, we have filed a petition that the compromise has arrived at. Also, with regard to offences not made
You are arguing
out.
on merit or you are arguing on compromise?
On compromise, Your Lordship has not said.
You'll be arguing to show a case that no case of sexual offence has been made out.
324. 324 is not made out.
No, but then that is the submission of merit, isn't it? Now, if charge has not been framed, then you argue it before this trial court. Go and file a discharge application there.
We have filed an application, but that order is also here. But the case was not disposed of.
That is very confusing.
Was compromise.
Submission. Your submission is.
They have
we
not
we have
argued
been able to
before
make out.
charge. They have not argued before charge before the trial court. That's 324 is not made out. What they have submitted is a petition saying that they have arrived at a compromise and that they should be allowed to.
Quashing it means compromise,
Yes.
not on merit.
No, on merit.
But they had submitted an petition for compromise where the accused, the victims and the actual accused persons were not the parties. So which is why on the last stage, Your Lordship was saying that, if Your Lordship recalls,
I have come here by this.
They are not a party in
the compromise, to the contract or the compromise agreement. It's only the complainant who is one of the parties and one accused person.
And that accused person is also complainant in the counter FIR.
Wait, one by one. Victim and the accused are not party.
The victims and the accused, all the accused persons are not party. Only one accused person is a party, whereas there are 4 accused persons here.
Okay.
On the last occasion also we have argued on this point, Your Lordship.
No. This sounds to be very something very unusual that a quashing has been sought, both on those grounds. One is settlement, one is merit.
That no charge.
If it's a settlement, there is
Yes,
no
on settlement, but the Lordship was not satisfied because why the
so then you have to give up either of the thing.
So I would have to give up that. I would want to argue that 324 is not meted.
So you will argue it on a matter of merit.
Yes.
So you specifically drop that thing that there is
The
no
compromise agreement is not being pressed.
Okay.
Yes, Your
Okay. That is what.
Yes,
that is what. Are you clear in your mind, Mr. Counsel?
Yes, Your Lordship.
Yes. Okay. What is the section involved in this case?
Section is 323.
323, 324 and 34 I see.
This 324 is not compoundable.
Not compoundable.
Not compoundable. 323 is compoundable.
24 is grievous order.
Grievous offence.
Grievous.
323, 324 and
34 I see.
Okay, just tell us what is your point of
Lordship,
view.
before I read out the statement of the victim and the
Recorded
complainant.
by?
Lordship. Sorry? Recorded by the police. It's an extract from the charge sheet. Lordship. Or from the case ID. Lordship, before I read, Lordship, I would just like to read section 324.
To what extent you can go to all those things at this stage to determine the merit?
Just to show what I want to point out, Your Lordship. 324 is not, the ingredients of 324 is not there, Your Lordship. From the statement of the
but then can it be a ground at this stage? What
a
about
little bit of evidence to show that the offence under 324 is
it can be
because
it can be changed, it can
yes,
be altered. 216 CRPC is there.
I understand.
Then?
But just permit me to show, because the reason I have come
No,
before
you
Your
see, we'll permit, you are not stopping, you see. Basically, if you are doing something with a purpose, then we have to see what that purpose falls within the framework of law.
Exactly.
Now, if your argument is for the purpose of showing that ingredients of 324 is not there, but then if it falls under 323, then also the case has to be there.
Yes, but again, that if 324 is dropped, because 323 is compoundable, then my petition, which I had filed earlier,
No, but then
that
the dropping and not dropping, we cannot do it at this stage.
I understand.
That is why this court said that 216 is there. What 216 does, allows a trial court to alter charges.
Exactly. Exactly.
Anyway, you argue, there is no problem.
As Lordship is aware, 324. The ingredients are that
161 to what extent at this stage you can go?
161.
No, but then in such a case, if you are here on merit, then you have to first show that you have argued your case before the trial court on merit, and trial court declined it, then only we will come. Otherwise, why should we interpret? We will not look in the merit. Yes, madam, is it not the law?
Because
Yes, Your Lordship, because if they have
to go for discharge before the trial court, isn't it?
that opportunity for consideration of charge or argument before charge is always given to the accused persons, and they should avail that before coming here.
Yes, exactly. That is what the law is.
Which is not been done as of now, Your Lordship. They have only sought for compromise because of the compromise agreement they have arrived
That is
at.
falls under 320. That is the difference.
320, but here the lower court is not in a position to allow that.
You go and approach the trial court.
Yes.
Actually, but this court also has the power. I'm relying on Bhajanlal and Devendra matter, where on the face of record, if the offence is not made out, the FIR, the evidence, if not made out, then
See,
this
evidence is
proceeding has
not
to
this
stop.
thing. See, FIR,
There is
that
no
is good
evidence
enough.
as of
Bhajanlal deals with FIR, not evidence.
I understand, but also and also in the Devendra, the evidence to a certain extent has to be touched to understand.
What will be constituted? What will be taken as evidence at this stage?
The 161 statement, and also in the medical report, very clear, simple injury.
No, see, medical report, is it binding? If you say simple injury, then you face a trial of 323. Whether that power to convert is available in the trial court. We will not do it at this stage. See, one thing is that 482, you cannot ask High Court to conduct a mini trial before a trial is actually held. That is what the law is. So we will not hold a mini trial to determine your case. Now, if you want to say that FIR doesn't disclose an offence, okay, and even the charge sheet filed also does not disclose an offence, we can interfere. But then show us then in such a case that say that charge sheet doesn't have.
That's not sure. 324 especially.
320 especially means
324.
No,
the
you are
offence
again
under
saying
which
that about converting the things. See, Mr. Counsel, I do not know what kind of, you are just trying to make evasive things. That if I fail in this, then I will do this. If I fail in this, see, tell us clearly what your case is. You want quashing of the matter. First you came up with the case.
Understand, sir, because 323 will be left, I understand. So, in that case, if not inclined, then I withdraw the liberty.
So there is no question. If you can satisfy the court, that is okay. But then we want to know the limit.
Only in 324.
See, this court is not putting any obstacle on you. But then court must understand you are arguing with what purpose.
Yes, sir.
Then we can begin. If you say for quashing, then we will proceed that way.
Yes.
Then you confine yourself to the FIR and the charge sheet.
Exactly.
Now, if you want to come something like a discharge and all, that this court is not doing that.
And also one thing, if Your Lordship with regard to this petition, this Lordship was not satisfied because the parties, the petitioners here did not sign but here, Lordship, they have come on
That is
oath.
one thing, if until and unless somebody is there.
This
But then
criminal
we do not
petition,
understand why you are taking up so many these things. If parties are in touch with you, why don't you execute one compromise, proper
already
compromise?
executed, already filed. But the thing is that at that point of time, why just two parties? Because they were the complainant.
You can correct it. You can correct it now. You correct it now. You withdraw this application with liberty. We will give you liberty.
Then I will withdraw. I'll withdraw.
And then come with a proper, until and unless there is a difficulty on your part.
Yes. No, not.
You see, you do not take that court is pressurizing you. It has to be a voluntary thing. The court has expressed its, you see, like view at what appears as of now. Okay. So that is what. You take a voluntary decision, what would be better for you by taking into consideration all those propositions. But then don't expect that court will be holding a mini trial at this stage. That is neither the intent of Bhajan Law.
Yes, sir.
So what ultimately you decide? What?
Withdraw.
With a liberty or without liberty?
Liberty.
We will allow them, please. Heard learned counsel for the parties at some length. Stop. After arguing for some time, Mr. Martna, learned counsel, appearing for the petitioner, sought permission of this court to withdraw the matter with the liberty to file afresh. Paragraph 0. On prayer being made, this petition stands dismissed on withdrawal with the liberty as prayed for. You can correct it. I do not know why you are going through so many hassles.
The reason we had to come here, Your Lordship, is because one of the
T24, once you have a compromise, did valid compromise this matter so far?
Yes,
I don't think court will be definitely inclined to interfere. And such a case, there will not much objection also.
Yes, sir.
Why parties are not here?
No, one of them is not here, who could not be a party. The reason being because these are very young kids. These are 21, 25 years old. They have a bright future. One of them recently got a job in the force.
So
and
anyway,
his
you contact him, have a discussion, and then subsequently you know how to do it.
Thank you. Pleasure.
Pleasure.
पीछे 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 आता क्यों नहीं